Excuse us.
I got ready now. I just put out my one. It is well. Bless you, brother. Bless you. You ready? That's
because nobody was here before. That is why. Or you can hold it. You can hold it. Abel, can they come back? Go back. Go back. So that you get them. Go back. Go back so you can get more people.
Are we ready?
Yes. Please, just a quick one, sir. Good afternoon.
Yeah, sure.
Please, we just want a designated. Sorry. It's not.
I know it's not a place.
People, we just need a clarification on the ruling on the EDMA. What exactly is the position of the court on that for the benefit of that? Was it dismissed? Was it rejected? Or what are we supposed to take out of it? Please?
Well, the ruling is simply requires Nnamdi Kanu, the defendant, to enter his defense. It's not a pronunciation of guilt or not guilty. So that is why it's called a no-case submission. So the judge made a ruling that there's a prima facie evidence that needs to be explained. So in common parlance, it calls on him to come and mount his own defense. But there is the other aspect of the ruling that concerned extraordinary rendition. That very one is one that compounded us, because the extraordinary rendition of Nnamdi Kanu is so open and notorious. Two international institutions or two separate panels of the United Nations have made pronouncements regarding his extraordinary rendition and called for his unconditional release. Nigeria is a member of the United Nations and therefore bound to consider that and implement that decision. And in Nigeria here, 3 courts have made similar pronouncements. First was by the Federal High Court of Umuahia, which awarded him 500 million naira. And the Court of Appeal also pronounced that he was a victim of extraordinary rendition. And in the Supreme Court, the same Supreme Court that sent this case back to trial, reached the same conclusion, that he was a victim of extraordinary rendition. And all these things are of the record. They are all in the file. And we remember when this trial was being conducted, these very documents were tendered in evidence. So it compounded us, it confused us, that the court now made a pronouncement that the extraordinary rendition had no evidence before the court, that no evidence of it was submitted before the court. And you remember, least but not the last, recently a Kenyan High Court made the same pronouncement. But well, if the court was misled by believing by mistake, that these things were not in the evidence, it also said and left the door open that such evidence be submitted. So we are coming back with that evidence, and it's going to be quantum and legion.
So what about the first application on the NMA?
Well, that one too, it wasn't in evidence that the Nigerian Medical Association has intervened. So it came as a surprise. Well, there's a short date given of 8 days for the NMA to submit its report. So somebody is ill, somebody is ill. You know, I don't think NIA is going to change much of that. But I think the judge wanted to leave the record open to admit every possible evidence regarding this matter. But meantime, we are disappointed. Our client remains ill and remains detained. And we're not happy about that. His situation requires urgent and emergent care. So whatever the court says today does not mean that the government shall withdraw back. Just 2 days ago, I wrote a letter. A private hospital has also expressed readiness to admit him here in Abuja. For security reasons, I won't mention the name of the private hospital. But the government, if the government appears to have issues with taking him to the national hospital, we have given them an option of a private hospital also here in Abuja.
So it's safe to say that the application to be transferred to the national hospital was rejected?
No, rejected? No, it's pending.
Okay.
Yes.
One other information.
It hasn't been rejected.
Okay,
it's
very well.
pending. It's pending the admission of this report from the Nigerian Medical Association and the opinion of the Nigerian Medical Association. And you know, if you were in court, the judge had ordered that the committee or panel to be considered by the Nigerian Medical Association shall have a member from the National Hospital. So National Hospital is still in play.
Thank you very much.
One other information, please. One other information. To try Nnamdi Kanu. Because that particular issue of being a victim of extraordinary rendition must be determined. And that one will be whether they will be the one that will confer jurisdiction on the court. And the court said there is no evidence before him. Now we are going to supply evidence before him that Nnamdi Kanu was extraordinary rendition. Then having done that, there is no case to answer. So that you should go home with that. And if they fail to do otherwise, we will not see it as a war against the Igbos.
Thank you.
And just like he said,
in this country, 2 sets of rules. One rule for the Igbos and one rule for every other Nigerian. This is a unique opportunity for Nigeria to be circumspect and look towards a political solution to this matter, and especially as it concerns high crime and criminality in the Southeast. So we are all disappointed, but God has not spoken yet. We will come back and show that the extraordinary rendition was indeed included in the submissions made to the court, and then the judge, like the barrister said, we will know whether he has jurisdiction or not. But for the Igbo people, this is your time to rise up and to speak up and to say enough is enough.
Enough is enough.
Yes.
Who did nothing? And you think that you come here and talking